Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Illinois. We have spent a lot of time here at Washington Gun Law describing what has been going on in your state, and it has been an absolute horror story. Now, every time that I think that your governor could not get any more evil, any more sinister, any more nefarious, what does he do? He basically just says, hey, hold my beer, watch this. And today is yet another example, and it may be an example that would only exist in a state like Illinois with their history of very questionable politics. So today, let's spend a few minutes because this is really important and this is really disturbing, especially in 21st century America. So let's spend a couple of minutes today and talk about when your governor starts playing dirty politics with your Second Amendment rights. Okay, so the story we're talking about today is yet again Illinois' assault weapons ban, which started as House Bill 5471, an innocuous piece of insurance legislation which ricocheted around in Springfield for a while, only to suddenly be put in committee, rewritten into a complete assault weapon ban, passed through the House, the Senate, and signed by the governor and effective immediately, all in less than 72 hours, because that's the way legislation normally works in the United States. I want to give credit to the folks who tipped me off on this story. It's this website, Moms at Arms. That's at momsatarms.com. Listen, check them out. A fantastic group, really bird-dogging what's going on with your Second Amendment rights. So I want to thank the ladies over at Mom at Arms for giving us the idea for this story. Okay, so last week in Illinois, a downstate judge, apparently that's the terminology they use in Illinois, a downstate judge in Macon County ruled that 5471 violated the Illinois state constitution. An interesting ruling, but a ruling nonetheless. Now, he issued a full injunction against the enforcement of that legislation, and then there was a lot of debate between plaintiff and defendants counsel whether that injunction was only good for the county or good for statewide. Now, Governor J.B. Pritzker had a very Gavin Newsom-like response upon hearing this ruling when he was quoted as saying, "We expected political grandstanding from those more beholden to the gun lobby than to the safety of their constituents, and today's ruling comes as no surprise. It does not apply statewide." And of course, that launched the debate about whether the injunction was countywide or statewide. However, Illinois Attorney General Kwame Raoul immediately filed an appeal with the Illinois State Supreme Court, and that's where things began to get a little interesting. And they also happen to get a little dirty. You see, the Illinois State Supreme Court has a slim one-judge majority to the liberal side, and that majority was maintained in the election in November of 2022. Now, prior to that election cycle, Governor Pritzker had himself signed legislation which limited campaign contributions to judges to $500,000 per person. So an individual would only be allowed to give a judicial candidate $500,000. As the races began to tighten in September of 2022, Governor J.B. Pritzker dipped into his own campaign fund and donated $500,000 to two judicial candidates. One was Elizabeth Rochford, and the other one was Mary Kay O'Brien. Now, you can imagine in a statewide race for a judicial spot how much $500,000 would help both of these judicial candidates. Now, remember, that money came from the governor's campaign fund. However, in late October of 2022, just before the election cycle, Governor Pritzker personally dipped into his own personal trust account and donated an additional $500,000 to both of these justices. Let me say that again. Governor Pritzker signed a law that said that an individual could only give $500,000 to a judicial candidate. He then gave $500,000 each to two judicial candidates. He then, 1 month later, dipped into a different account and pulled another $1 million out, giving $500,000 to Elizabeth Rochford and another $500,000 to Mary Kay O'Brien. It would appear to be a clear violation of the very law that Governor Pritzker himself had signed into legislation. Now, Why is these campaign contributions so important? Well, the Honorable Elizabeth Rochford and the Honorable Mary Kay O'Brien are two of the Illinois State Supreme Court justices that will be hearing this appeal, in which Governor J.B. Pritzker is the first named defendant in the suit. And if your head is spinning, let's just rehash this for a second. Governor J.B. Pritzker violated his own campaign contribution law, giving twice as much money as what was legally allowed to two judicial candidates who now reside on the Illinois State Supreme Court and will be deciding the injunction in which Governor Pritzker is the named defendant in. Only in the state of Illinois could that be possible. Now, these campaign contributions from Governor Pritzker and other special interest groups led the New York Times to do a story that more money was spent in Illinois judicial races than in any other state in the nation during that election cycle. Worse yet, the Political Action Committee, which basically coordinated most of these spending efforts for liberal justices, including the two that were elected to the Illinois State Supreme Court, did not disclose $7.3 million worth of expenditures until after the election. But the absurdity does not stop there, you see, because both of these justices and Governor Pritzker were not quiet in any way, shape, or form about their support for each other, nor were either of these two justices quiet at all about their absolute disdain for Illinois individuals' Second Amendment rights. There is social media post after social media post after post that shows both of these justices working in close combination with Governor Pritzker and other gun control groups to advance this sort of legislation. Now, there has been an adage that perhaps corruption is somewhat built into the Illinois system, and I had an opportunity to take a look at the Illinois rules on judicial conduct. And I must tell you that there is some pretty unique language that I have not found in any other state. Take, for example, Judicial Rule 1.2, which specifically states, a judge shall act at all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety. However, when you take a look at the comments to the rule, you'll find comment number 3, which specifically states, conduct that compromises or appears to compromise the independence, integrity, and impartiality of a judge undermines public confidence in the judiciary. Because it is not practicable to list all such conduct, the rule is necessarily cast in general terms. So even though a justice is told to act in a manner that protects the integrity of the bench, it's really just in general terms, and it's kind of advisory in nature. Okay, so the underlying case, once again, is Caulkins v. Pritzker. It originated out of Macon County, injunction granted, appealed by the state of Illinois to the Illinois State Supreme Court. We will keep our eyes on this because I want to see if these two justices do what's right here, because what's right is that they would both recuse from this case. In the meantime, if you have any questions about what's going on in Illinois, or if you have any questions about what's left of our Second Amendment rights, you guys should know the drill by now on how to contact us. Our contact information is listed in the description box down below. Please remember that part of being the lawful and responsible gun owner, like we always talk about here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.